We utilize like a building and ad hoc for the power. I've seen the building things, but the perfect so. This is the only way we had one this morning. All rise. Court of Appeal in 46th District of the State of Florida Town Session. Honorable Mary Ann Ardella, Judge presiding. All persons having business before the court, all near give attention and will be heard. God save the United States of America, State of Florida, and this honorable court. Please be seated.
Good afternoon. My name is Judge Nardella. Welcome to an oral argument session of the 6th District Court of Appeal. We have one case on our docket this afternoon, and that is the case of the state of Florida versus Brian Allen Reppel, and the number is 23-1448. Joining me on the panel today are Judges Carrie Ann Wozniak and Judge Joshua Mize. We will begin to proceed. As counsel probably knows, the arguments today are going to be live streamed. Each side is given 20 minutes time. The state, as the appellant, will start. They can reserve as many minutes as they like. We have preset for 5 minutes. Is that acceptable, counsel? Okay. Whenever you would like, please come to the podium.
Thank you.
May it please the court. My name is Richard Palace. I represent the state of Florida. The trial court entered an order granting a motion to suppress the breath test results of the defendant. It granted this relief because while the Maitland Police Department executed a lawful investigation of DUI and arrest of DUI within the municipality of Maitland, they then moved the defendant, transported him to the Orange County Sheriff DUI Center in Orlando, outside the municipality. At this time, they also read the implied consent warning, and then the breath tests were administered.
Counsel, we all read the briefs. We know the facts. I was really surprised by something in reading the briefs and the case law, because it seems to me that kind of a fundamental issue was missed. And here's what I mean by that.
Yes, Your Honor.
You have several cases from different DCAs saying municipal police officers cannot act outside their jurisdiction. Doesn't say why, it just says that. And then on that basis, they say, you know, police officers cannot do things that require them to be police officers when they're outside their jurisdiction. Okay, and then you had Torres, which you rely on, which basically says we accept that, but we create an exception, right? Or we think there is an exception for ongoing investigations. They also don't say why, other than we think it's reasonable. And I actually thought the fifth, you know, kind of conflicted with the fourth, because if you look at the exceptions the other DCAs had recognized, you had the ongoing investigation exception, as the fourth articulated it, was that they can do things outside their jurisdiction that a normal person could do, that doesn't require them to be a police officer. They can observe things with their senses. They can speak to witnesses who speak with them voluntarily. Exception's kind of a misnomer. That's not really an exception, because they're not doing anything outside the jurisdiction that requires them to be a police officer. That's not an exception to the doctrine. That's just not subject to the doctrine. And then you have the mutual aid exception, but that's not really an exception either, because if a municipality enters into an agreement with the county and the county effectively deputizes the city police officers, they're also not acting outside their jurisdiction because they've been deputized by the county, right? So you have the fourth and some other DCAs recognize this doctrine. And they had these quote exceptions that weren't, in my mind, exceptions. And then you had the fifth say, hey, we are going to remove the limitations from this quote exception. Nobody really got to the fundamental issue, which is where do municipal police officers get their power to act, and what is the scope? And here's what I mean by that. The sovereign power in the state government lies solely with the state government. Counties don't have it, cities don't have it. Cities execute sovereignty that is delegated to them by the state, right? So it's in the Constitution. The state legislature, if a group wants to apply to be a city, which Maitland did in 1958, they apply to the state legislature, and the state legislature passes a law creating the municipality and delegating certain powers to them, right? So
Yes, sir.
it seems to me if the state wanted to, since the state indisputably has statewide police power, the state could certainly tell municipalities, we are granting you police power. You can deputize police officers, and they have statewide authority because we have statewide authority and we're delegating that to you. They could also tell municipalities, we're granting you police power and you can have police officers solely within the metes and bounds of your city. Okay, so it seems to me really relevant which one did the state do? Okay. And I didn't see, because if the state gave them statewide power, then they've got statewide power. If the state said you have power within the city jurisdictional limits, then they have power within the city jurisdictional limits. And I don't see how we create an exception to that. And none of the briefs and none of the cases from the other DCAs got into where that power comes from. And the only place I could think it would come from, I looked for a lot of different places, would just be the law creating the city of Maitland. We know it was passed in 1958 because that's when the city of Maitland was created. I couldn't find the state law creating the city of Maitland. So, did anybody think about this? Did anybody get down to the fourth fundamental issue? And I'll ask the opposing counsel the same thing. Does anyone know, what is the state statutory authority for cities to have police officers? Like towns don't get to have police officers, right? Cities do. Towns are created by the legislature too, but they don't get to have police. So what is the base authority from the state for city to have police officers? What is the source of that authority and what is the scope?
Well, Your Honor, with looking at the scope, or let's say the source of this authority here, it certainly takes me back to taking Florida constitutional law back in my 3L years. But here, of course, none of this was argued below by the state. So it was certainly not on my mind, at least in designing any of the briefs in this case, with finding the source of this power to the municipality of Maitland, or for that matter, to the sheriff's office of the counties. So
Do you stipulate as a general matter, municipal police officers cannot act as police officers outside their municipality?
No, Your Honor, that would, we're of course looking at this, Your Honor, as an exclusionary rule with under the color of office doctrine here.
Well, the exclusionary rule implies there was a constitutional violation, but we're not going to exclude the evidence, right? So that's what the exclusionary rule is when you do not exclude evidence that was obtained in violation of the Constitution, right? I'm asking you about the underlying violation as a general principle, and I know you might argue there's exceptions, and you can say there's an exception here. I just want to know your base position. Do city police officers, as a general rule, are they limited to being police within their city?
Your Honor, yes, that is actually stated in the case law that as a general matter, a law enforcement officer cannot hold himself out as a law enforcement officer in an area where he does not have jurisdiction.
Yeah, we agree, counsel. But I think just Judge Mines' question is, where does that come from? It's cited all over the case law. Where does it come from? Why is there a territorial limit?
Certainly, I would have no problem doing further briefing into this, and both looking into the charter of the municipality of Maitland, and also I believe combing the catacombs of my mind here, I know there is certain provisions of the Florida Constitution that specifically talks about, I believe, the establishment of our municipalities and maybe power in a broad sense, delegating the police power to them. Goodness knows they reference certain items like home rule within them. And that, of course, our version of the supremacy clause, that state law is going to control over that.
I looked at that. It basically says that, municipalities shall have the power necessary to conduct municipal services except as provided by general or special law. It doesn't reference law enforcement specifically, and it would still be subject to law, and presumably there was a law creating the city of Maitland.
I mean, goodness knows, in terms of anything that's statutory or constitutional, Your Honor, I can honestly tell you at this moment, I could not name anything off the top of my head. But besides, of course, our various statutes talking about mutual aid agreements, stop and frisk, searches incident to lawful arrest, and of course, the fresh pursuit doctrine.
The
And
fresh pursuit has a statutory authorization, right? So it's
yes,
like
Your Honor.
city police officers exercise state authority. The state could certainly say all city police officers have statewide authority if they want. Seems like you agree they didn't. As a general rule, city police officers are limited to being police officers within their city. And we just can't figure out why though.
Well, yes, Your Honor. I would agree, of course, if the Maitland police officer here had executed an arrest within Orlando and then proceeded to, while still within Orlando, no hot pursuit, no mutual aid agreement in the evidence, nothing indicating any exceptions to these requirements. That is something where exclusion would certainly be warranted here. So now,
Counsel, I want to move on to the investigation, the pursuant to an ongoing investigation exception, which you rely on and the Torres opinion relies on.
yes, Your Honor.
And my specific question is, what is the foundation of that exception? Having looked at all the case law cited, it seems to be one case cites another, cites another, cites another. And there's certainly a lot of cases that stand for that premise. But what is the foundation for that exception? Is it a statute? I think you can see that it's not. Is that correct?
That is correct, Your Honor.
Is it the Florida Constitution?
In terms of, I believe, looking into exceptions to the warrant requirement, at least within the Florida Constitution, but not within the text of the Constitution, I believe itself. But of course, there's nothing stating that name within our text, either Florida or the United States.
Is there some common law foundation that provides the basis? And what is that?
Yes, Your Honor. Most of our exceptions, for our Fourth Amendment exclusionary rule, they've been judge made. I mean,
Counsel,
goodness.
you keep confusing me when you speak to the exclusionary rule. And I'd like you to you can make it whatever argument you want, but I'd like you to be clear.
Yes,
The exclusionary rule means you exclude evidence that was obtained illegally. And there are exceptions to the exclusionary rule. But if you're under the exclusionary rule, that means you're ceding that the search was illegal, because the exclusionary rule and exceptions to it only apply when you have an illegal search. Then you just have, was the search legal? If the search was legal, you don't get to the exclusionary rule. So,
yes, Your Honor.
because it seems to me like you're arguing this search was legal. Am I wrong about that? Or are you
We
arguing?
are
it was-
arguing that the seizure of this defendant and his breath test results was legal. Yes, Your Honor.
Okay, well then, why is the exclusionary rule relevant?
Just thinking of it as the general standpoint that this was excluded by the trial court below is, I think.
Okay,
why
because she
I'm
found it
speaking
was
general.
illegal. Because she found it was illegal.
Yes, the trial court below found that this was illegal.
Okay.
Yes, and that's why I think we're sticking with this level of the lexicon here, and specifically speaking an exclusionary rule and the like.
Okay, but you're not arguing any exception applies. You're arguing the rule doesn't apply because it wasn't illegal.
That's correct. We basically say the under the color of office doctrine just does not apply here, because instead we're subject to an ongoing investigation. And to answer Judge Nardella's question necessarily, this is judge made. Most of our exceptions or authorizations of law enforcement in our statutes typically follow common law that's created out of our courts. I know the private or the certain ways where you can make arrests in terms of breach of the peace, or when you've noticed a misdemeanor in the presence. Those came out in cases as far back as 1939, I believe.
But didn't all those say it was a citizen's arrest and that officers, even though they're not officers outside their jurisdiction, don't give up the right to make a citizen's arrest like anyone else? That's not really an exception of the doctrine. That's an example of the doctrine, right? They're not acting as police officers.
And those cases are saying that basically you're not under the color of office, you're just arresting someone as a private citizen can.
Okay.
Now, at least the case out of the first DCA in Wilson, which came out in 1980, that we cite in the supplemental initial brief, that actually delineates between the ongoing investigation exception and then details committing an investigation using only your very senses as.
So in other words, not acting as a police officer.
That's correct, Your Honor.
So it sounds like to me, counsel, your argument is you agree as a general rule, municipal police officers cannot do things outside the municipality that require them to be police. You think that there is an exception to that rule, that is the ongoing investigation exception, that you think other DCAs have created on their own.
Yes,
You don't have a source of authority for it other than other DCAs have created it. And you would like us to also create that exception in the 6th DCA. Have I summarized it correctly?
I believe, Your Honor, yes to all, except for that. This was, I would say, created out of nowhere. It's just created out of our DCA case law. Of
Correct,
course.
but you don't have a source where the DCA's got it from. The other DCA, I'm not saying you created it, but the other
Of course,
DCA's created it. You don't know where they created it from. There's no source, but the other DCA's created it, and you would like us to also create it in the 6th based on the other DCA's having created it. Am I right?
Well, yes, Your Honor, but I mean, by that stem of logic, we're looking at the under the color of office doctrine was essentially created by the DCAs as well. The state pointed out that when the 2nd DCA held this in Collins, the 1962 case out of the 2nd DCA, it cites generally to both Dunavant, which is a Florida Supreme Court case that doesn't apply here due to that it had to do with just a search warrant lacking.
So what you're saying is, that if you say the DCA has created the under color of office doctrine, you're saying the DCA has created the limitation that they can't act outside their municipality, so they can create an exception to that limitation. Is that what you're saying?
That's how I would, if we were to say that DCAs have merely created the ongoing investigation exception, the under the color of office doctrine was in turn created out of.
How do you know that if you haven't seen the document that creates the city of Maitland?
Well, Your Honor, it typically would.
Like, what if the law, and I couldn't find it, so I'm asking, I looked, I couldn't find, municipalities have to be created by a law. There's got to be a law. I looked on Westlaw, I couldn't find it. If the law that created the city of Maitland says, we, the legislature, delegate to the city the police power to be exercised solely and only within the metes and bounds of the city of Maitland, then that would mean the color of office doctrine was not judicially created, it was statutorily created, right? But that the exceptions to it, the ongoing investigation exception, which again, only in the 5th is actually an exception. Everywhere else is just an application of it because it doesn't actually allow them to do police things outside their municipality. So the 5th, there was a statutory limitation on where municipal officers can operate, assuming that is in the law creating the city of Maitland. And the 5th created an exception to that on its own.
Well, Your Honor, I believe the 5th was applying this exception coming out of cases from the 1st DCA and the 4th DCA.
But those DCAs all said you can only do things that don't require you to be a police officer, didn't they?
No, Your Honor.
Okay, which one said otherwise?
I know that both Wilson, the 1981 out of the 1st DCA, does not state that. In fact, it clearly lists for the case, if this will make it a little easier to pull that one up. Wilson specifically talks about private investigation or investigations by private individuals.
Correct, that's my
Yeah.
point. They were investigating as a private individual. They didn't do anything that required them to be a police officer.
But that was discussed separately from the ongoing investigation, Your Honor. You detailed that afterwards. The Wilson case, I'm so sorry. It is 403 Southern 2nd 982. It first refers to the ongoing investigation exception, citing to Chapman and Parker, which were, I believe, respectively, 4th DCA, or I'm sorry, a 3rd DCA and a 1st DCA case. And then it notes private citizen investigations, citing to Shipman in that particular case. And of course, cases like Knight out of the 1st and Nunn, while Knight was also admissible as a mutual aid exception, that was another where it discussed this. Goodman out of the 4th DCA, which came out in 19.
Counsel, I read those cases.
Well,
None of them, other than Torres, I agree with you about Torres. Other than Torres, which of those cases did the police officer do something outside of his municipality that required the police officer to be a police officer?
Specifically just making an arrest or actually requiring someone to take.
So the cases involving an arrest, the court said it was a citizen's arrest. He didn't have to be a police officer. The investigations, other than Torres, were the officer didn't do anything that required him to be a police officer. He went and talked to witnesses. Anybody can do that. You could do that. Any private citizen could do that. He went and observed things. Anybody could do that. A foreign national could do that. They could get a visa and come here and talk to whoever they wanted, right? None of the cases other than Torres did the police officer do something that were outside of his municipality that required him to be a police officer. Am I wrong about that? Is there a case other than Torres, which I agree with you about Torres? Is there a single case other than Torres where an officer did something outside of his or her municipality that required him or her to be a police officer and a court upheld it under the ongoing investigation exception?
I would say aside for Goodman, Wilson, Parker, I believe those are the main ones that we are citing as sourcing this, Your Honor. Aside for those particular cases, and of course, Torres being the most express about this, most of those cases just talk about this law as a whole and then say that another exception may apply. But out of all this, we believe that, I mean, the Torres case is correctly decided. And even if we're looking at this as reading implied consent as a municipal officer who's no longer within his municipality, unless I see law that says that there's no source for this, I will go by what the decisional law is, Your Honor.
Counsel, you're into your rebuttal time. Would you like to save the remaining time?
Yes, Your Honor, I'll save the rest of my time at this time.
May it please the court, we believe, just as Justice Mize has stated, that
No promotions.
it's not.
Counsel, can I make sure that I understand your logical chain of argument correctly? It's my understanding that you're arguing that administering a breath test is a search. The Fourth Amendment requires searches to be reasonable. It is unreasonable for a police officer to use power when he's not authorized to do so. A police officer is authorized to exercise power within his jurisdiction. A police officer, absent express statutory exception, is not authorized to exercise power outside of his jurisdiction. No statutory exception exists in this case. Is that fair?
It's fair, except the only thing I would add to that is that in Florida, under Florida statute 316.1932, there is an express statute which is unambiguous on its face, and it specifically requires that when requesting a breath test, it be a law enforcement officer.
Counsel, I did have a question about that argument you were making. You expressly say that it was not a lawful arrest. I did not understand that argument, or did I misread your?
Well, I don't know that I said it wasn't a lawful arrest, but the way it works in Florida is under Florida statute 316.193. There's two ways to convict or charge somebody with a DUI. One is driving under the influence of alcohol to the extent their normal faculties are impaired. The other is driving with an unlawful breath alcohol level. Obviously, you can't charge somebody with driving with an unlawful breath alcohol level until you give them a breath test. So and I'm not sure what you were referring to, but I at one point was arguing that when the municipal police officer takes the individual down to a breath testing facility located outside his city limits, and then he asks that person to submit to a breath test, he's seeking to charge them with a new crime, unlawful breath alcohol level. They've already been charged with driving under the influence of alcohol to the extent their normal faculties are impaired. But unlawful breath alcohol level is actually a new charge that's being created outside the jurisdiction of the police officer. I think that was what I was arguing.
Understand, counsel. My follow-up question is, and you mentioned the transport, and I think that's important because the cases they cite, I believe in Rhode Island, the cases out of the state, which they cite, rely upon an analysis of the transport, not necessarily of the search. And below, you seem to hit on both. At this level, you seem to be harping on the fact that the search was done outside of the jurisdiction. If we were to agree with you, would we call into question the transport of a municipal officer to, go ahead.
I don't believe in just transporting somebody similar to a private citizen could go to Tallahassee. If I'm a municipal police officer, I could go to Tallahassee and I can investigate a case from the city of Maitland or Winter Park or whichever it might be. And I could go ahead, maybe look at a farm out there, and anything where I don't use the color of my office in order to obtain evidence that's not otherwise observable.
I understand the obtaining evidence, but the detention of a defendant in your police vehicle outside, go ahead.
I don't believe that that's using necessarily color of office because of the fact that he's not trying to obtain evidence by just transporting somebody.
Well, yeah,
Understood.
but.
Go ahead.
Okay, go ahead.
If we were to say that a municipal officer's powers are limited because we find whatever statutory grant or because all the case laws say that they're limited to this territorial jurisdiction of the municipality itself. If we were to say that, how does that not become an argument that the detention outside was also an unlawful use of police power?
Well, it may very well be because there was one statute that I had cited in the supplemental brief, 901.25, which is the fresh pursuit statute. And in that statute, I think I pointed out in the brief that if a police officer leaves his jurisdiction in hot pursuit and goes into another county, he has to call the officer from that county to take that individual before a county court judge of that county that's outside of his jurisdiction. And to me, that's a sign that the legislature is saying, once the officer goes out of his jurisdiction, we're going to give him the right to stop a vehicle in fresh pursuit. But after he gets out of his jurisdiction, he doesn't have the full range of police powers that a normal police officer would have. And that I was suggesting was an example where he has to call in an officer from that jurisdiction to take over and bring that individual before the county court judge.
Counsel, what's your understanding? Because I agree, if you're a Maitland City police officer, to detain someone, you have to be a police officer my understanding is, and I want you to correct me if it's wrong, is that the counties and the cities deal with this through agreements, right? Like, don't the various cities have agreements with, say, the Orange County Jail, right? For, the city of Maitland or Orlando to take people to the jail. I mean, don't they deal with that contractually?
They might, I don't know per se how they do it. There's these mutual aid agreements that sometimes they use, but those are very specific on what officers are allowed to do in and out of each other's jurisdictions. So, there may be some kind of contractual, or it may be just convenience sake. They all came to an oral agreement and said, this is how we're going to do things. And that's sort of how this breath testing situation, I think, arose, because I've kind of been doing this for a while. And back in the old days, a lot of these jurisdictions had their own breath testing machines in the municipality. And it's only evolved into where we are at this point in time.
So if there was a mutual aid agreement here introduced into evidence, would we be here today?
Maybe, maybe not, depending on how it's written. And it's the mutual aid agreement law is very specific that it's kind of like a contract. It has to authorize certain things inside that agreement to allow the officer to do certain things, because they do give limitations to police officers that it has to be a certain kind of crime that they're enforcing out of the jurisdiction.
Correct, but you agreed they could craft a mutual aid agreement that covered the situation. There's just no evidence they did here.
I'm not saying you can't do that. I'm a little intrigued about the fact that the city of Maitland doesn't exist. The taxpayers, they'll probably be happy to hear that, but yes, I think you potentially could if it was done correctly. But then again, the mutual aid is also, there's been some case law as to whether or not you can just do general police duties through a mutual aid agreement, or whether it has to be like an emergency or some type of situation. There's been some case law that has disputed that back and forth. But I'm not saying that it can't be done, but it wasn't done in this case, based on what I know of whatever mutual aid agreement they have, because I don't think it's specific enough.
Counsel, if there had been an Orange County sheriff present during the breathalyzer test, would that have made a difference?
Maybe.
It's-
Because but then you run into a problem with a fellow officer situation with whether the municipal officer is a private citizen. It could be a fellow officer to the deputy who would be requesting the breath test in this case.
I guess I'm just thinking practically, the practical effects of our decision here. I mean,
So
how
the
would this-
practical effect would be, I don't want to interrupt.
No, go ahead.
To me, there's probably a pretty easy solution to all this. And that is the officer, while in his jurisdiction, could request that individual to submit to a breath testing machine that's within his jurisdiction.
So every jurisdiction would have to have their own breath machine, even a really tiny city, in another place in the state.
It's not quite as burdensome as some might suggest. I mean, they buy radar devices, they buy all kinds of devices for use in their municipalities for speeding cases and whatever. And a breath testing machine is probably $5,000 to $7,000
Or they could enter into a mutual aid agreement with the county for the purpose of taking
potentially. Yes.
persons arrested in the city of Maitland to the county breathalyzer situation, to
There's
the county
very-
breathalyzer station, right?
Yeah, there's various alternatives, but they weren't used in this case.
Counsel, you argue in your initial brief that a breath test should receive no different treatment than any other type of search. As you know, in Birchfield versus North Dakota, they describe the breath test as a search incident to arrest.
Right.
That is a category of searches. It seems different in kind than a search of a home outside of a jurisdiction. I just want to throw that and see what,
Yeah, the incident to arrest is a constitutional exception.
Right.
That has been come through the ages, the Fourth Amendment. But in this particular case, when you have a specific statute that says a law enforcement officer has to do the search, i.e. the breath test, even under Birchfield's a search, it's just incident to arrest, so you don't need to have a search warrant to do it. Whereas normally you'd have to have a search warrant to search. So I think that was a constitutionally created exception that doesn't exist in this case. Because this case, the state of Florida, through its legislature, has arguably given citizens greater protections than the Constitution by enacting a statute that says you're required to do a breath test, but it has to be requested by a law enforcement officer.
what if the state argues that he is a law enforcement officer and the statute didn't explicitly say a law enforcement officer with power to act in this jurisdiction or some sort of caveat? What would you say to that?
Well, then I'd go back to the Griffiths case from the Fifth District Court of Appeal, which was a search warrant statute that requested a police officer execute the search warrant. Didn't say that the police officer had to have power to act, but the Fifth District Court of Appeal in Griffiths found that that term contemplated a police officer with power to act. And in this particular case, my position is the municipal officer, even if he's a police officer in nomenclature, didn't have the power to act when he was outside of his jurisdiction. So to me, the two statutes, while they're different statutes as far as subject matter, one dealing with search warrants, one dealing with breath tests, they both use the term police officer or law enforcement officer. And the Fifth, at least, has gone ahead and found that it has to be a law enforcement or police officer with the power to act, and the same should apply to this statute. It should be a law enforcement officer with power to act.
Counsel, how would you answer Judge Mize's question about the authority of municipal police officers, where that comes from? Obviously, the cases represent a territorial limit. That certainly makes sense. Where do you think that foundation is?
I don't, honestly, the foundation is what I've read in the case law, but some people refer to an exception. I don't refer to an exception. A police officer, in my opinion, can continue an investigation outside of his jurisdiction. If something happened in his jurisdiction, but as the Phoenix case said, and as the Sills case said, that power to go out of jurisdiction and continue investigation is limited by the under color of office doctrine, wherein you cannot use that doctrine to ferret out evidence that's not otherwise observable. So I do believe, but we run into the slippery slope that if we condone a police officer using his power of office from Maitland, let's say in Tallahassee or Pensacola or anywhere throughout the state, what supervision do you have over him? He can do whatever he wants to do.
Counsel, I understand that slippery slope argument, but if we got big picture and we said that, like the Supreme Court has said, the touchstone of the Fourth Amendment is reasonableness. Why was this unreasonable for a municipal officer to go to the county in which the municipality resides? I understand, and reading it as Griffin reads it, that would require him. I understand. Okay.
And not only that, but also when you use statutory construction based on, if it's expressed in the statute and it's not ambiguous, you have to give the plain meaning of what it says.
Does the rule of lenity come into play here?
And I've actually thought about that one point, where a statute is ambiguous, it's supposed to be resolved in favor of the defendant.
But here, normally that would come into play in a statute that governs conduct, right? And a defendant is trying, you want people to be able to read the statute, know whether what they're doing is legal or illegal, and so you err on the side of legal. Here, it's a statute governing, it's a criminal, obviously involves criminality, but it's a statute involving criminal processes. Is there any case law that tells us whether a statute that governs criminal processes like this or searches is subject to the rule of lenity?
Well, the court, the 316.193 is actually governing criminal because, again, as I stated at the very beginning, you're creating a new crime, unlawful alcohol.
Well, yeah, but this statute governing the search doesn't pertain to the conduct that is illegal. It pertains to the method of investigating it. Is there any case law that speaks to whether criminal statutes that govern criminal processes are subject to the rule of lenity?
That would be an interesting thing to research. I have not researched that, thinking off the top of my head. But the way the statute on the rule of lenity reads, I don't think it's specific to a criminal behavior. I think it's for a statute that is ambiguous. Just off the top of my head, I'm thinking there may be issues where the sentencing guidelines, things like that, would think for ambiguous. I don't know if the rule of lenity may apply to situations like that.
Could the state of Florida pass a law saying all municipal police officers have statewide authority?
Certainly, there's the Florida Highway Patrol officer.
Yeah,
Florida Highway Patrol can go anywhere in the state as far as the law enforcement, go anywhere in the state.
yeah. So would you agree that the statute that authorizes Maitland to have police would be really, really important to us to figure out this question?
I think, yes. Actually, it didn't dawn on me until you mentioned it.
Like, for instance,
When I thought about it, it makes sense.
well, for instance, if it said, Maitland has authority to create municipal police who shall have authority, to be police within their jurisdiction and to do such incidental things outside their jurisdiction as relate to their jurisdiction, right? Like you could imagine language that would resolve this.
They could do that. Now, to give you an example where it sort of had been done, and that's for university police officers. Because originally, university police officers were limited to the campuses that they were police officers on. And then the legislature subsequently amended the statute to allow them to have enforcement authority within 1,000 feet of campus. And that allowed them to go to Orlando, UCF, they were allowed to go on to Alpena Trail, where before they could not go on Alpena. And they were allowed to enforce laws on Alpena Trail based on the legislature giving authority within 1,000 feet of the campus. So I think, yes, that can be done. Has it been done? Not in our way.
Just to be clear, is there a definition of law enforcement officer in chapter 316?
In 316, I haven't gone completely through the statute, but I don't think it is.
So what definition, is there a statutory definition that we're supposed to use?
I'm not sure there is, because there wasn't one in the search warrant statute in Griffiths, and that was construed to be a, law enforcement officer with power to act. So the same analogy would be with this statute, it doesn't have it. But I'm trying to think back, but I don't think they do define it. The definition section in 316.
And it's not in there
Okay, so
for what, yeah, but I'm just wondering if you agree or you've seen one and you can
Yeah.
advise us on.
Not that I've seen one, but that's why I'm talking two situations. In purpose with these also, they cited Phoenix in the purpose case. I thought that was an analogous situation, where I thought Florida's kind of went a little astray of purpose. And there was one
I'm sorry?
there was one that was another panel that was the DPA. So the fifth is, when we're in the fifth, it would be, the PCA goes fifth. Um, basically, my position in this is that this is a situation that is somewhat unique for the case for, except for the Montrose case, which was a, actual drug test case, and Florida's case. Montrose case is in Florida, obviously Florida, the 50s, but Montrose said that asking for a drug test was a use of color of office. And where I think that this is distinguished from the 50s case, Florida case, is that there is a statute that the legislature has passed, and they were allowed to give greater rights to individuals by statute than the Constitution.
What-
Stand by.
Would it be different if, say somebody gets pulled over for DUI, police officer performs field sobriety tests and says, I think you're under the influence, doesn't try, because they don't have to do a breath test. And the arrestee says, listen, I'm just clumsy. I'm not drunk. I have hand-eye coordination problems, whatever. Would you please take me to get a breathalyzer? I think that will show you I'm not drunk.
Yeah, the problem with that is that the response of the police officer is statutorily, I can't do that unless I arrest you. Because that's the incident to a lawful arrest.
Okay.
And that's what the statute says, and that's one of the issues I had with the Torres case, because it tended to be distinguished because of the breach of peace arrest. But if you look at the statute only requires a lawful arrest, the breach of peace arrest is a lawful arrest. But then you jump to the next step of the statute, is after the lawful arrest is made, it has to be a law enforcement officer that requires the arrest.
By breach of the peace arrest, you mean it's a citizen's arrest,
Yeah.
non-law enforcement officer arrest?
And going back also to the shifting case in those cases, when you go back to the history of this, those cases, there was the officer was acting in court said a private citizen, but had they held themselves out as a police officer, with all the cases would have found that the unlawful use of power of the office based on that motion. So when I put in the brief with the foundation, that as far as I can find, is the foundation for all this starting, but it's always been, with the exception of Torres, that if the police officer who's municipal uses the power of his office out of the jurisdiction, he can't use it to gather evidence. It's not either lawfully provided or that it's made available.
Council, your time has expired.
Thank you. Thank you very much.
Yeah, please support. Just a couple of points on the statutes and rebuttal. The rule of lenity is recently, the Florida Supreme Court has held the United States versus Canadian case that came out. That's a statutory canon of last resort that we're not going to get into until at least plain meaning and also a certain context of the statute. Now, implied consent regarding law enforcement officer, this is not the same situation as the Griffiths case. Griffiths concerns search warrants, and State Maxwell Wilson v. Quigg, which is what is cited in Griffiths, again was citing all cases that had to do with search warrants going into our homes, and that case law cited from that of Hart, Jackson, and Gildry, all search warrants in homes. Whereas we have cases like Johnson v. State, 660 Southern 2nd, 648, while not in any of our briefs, it talks about arrest statutes and how those are dictated by substantial compliance. So in terms of law enforcement officer defined within implied consent, I believe we're not dealing with a strict construction as in either the Moya or Shaker case that was cited in the answer, which specifically was then testing for something other than alcohol. Instead, they were testing for drugs. I think substantial compliance would apply more to implied consent. In addition to all this, I recall that there is also the search. We discussed the search instant to arrest statute more recently during, I believe, opposing counsel's point. And while of course not directly on point here with what we have,
you may search a person arrested to discover roots of the crime.
A police officer may conduct a search incident to arrest, right?
A peace officer, Your Honor.
Well, peace officers have statewide authority. Like judges are police officers or peace officers under the state constitution, right? It's like, forget which article it is, but. So peace officers are different than municipal police officers. Peace officers have statewide authority.
I mean, with what we, how do I view the peace officer making a lawful search in 901.21? I don't believe I see anything defined on peace officers, just strictly a statewide officer. Not familiar with that.
But a peace officer is different than a normal law enforcement officer, right? I'm a peace officer. I'm not a Maitland City police officer, and I don't become one if I'm somewhere else, and I can exercise the authority of a peace officer. I can't exercise all the same authority. There might be some overlap, right? But a municipal city police officer is not a peace officer. They're a municipal city police officer, right?
I mean, by that account, then 90121, but we have no statutory authority that actually execute searches and do a lawful arrest. I mean, I don't believe that everything needs to be delineated by statute, and when it comes to law enforcement being able to ferret out certain evidence of a crime. And
Well, law enforcement officers, it's part and parcel to their job to do arrests. It's contemplated by the Constitution, right? It specifically says, you can't have unreasonable searches without a warrant. And the search incident to arrest isn't an exception to that. What the Supreme Court has said is it's not unreasonable. It's not an exception to the rule. It's the rule operating. A search incident to arrest by a law enforcement officer is not unreasonable. Whereas peace officers have more limited authority. Okay, so I'm a peace officer. Every judge in the state of Florida is a peace officer. We can conduct arrests of crimes committed in our presence. We cannot go investigate a crime, right?
yes, sir.
So it would be because we don't inherently have investigatory authority, and we are, under a completely different regime, there might be a need for statutory authorization for us to conduct some kind of search. And I think that there's an attorney general opinion, like setting forth the procedures judges should follow if they ever conduct an arrest. God help the judge that does that. But whereas law enforcement officers don't need a special authorization because they're law enforcement officers. They investigating crimes is part of what they do. Investigating crimes is not part of what a peace officer does.
Yes, Your Honor, but I want to go back to, I know that I am eating into my time here, so it's one final point, if I may. By that, saying a search incident or arrest, we're not looking at it as an exception, we're looking at that as reasonable, then by that logic, I would say that our ongoing investigation principle that I've been detailing as to why the undercover office doctrine does not apply here, I would say it is not unreasonable. And it is in fact reasonable to continue an investigation that started the subject matter of which within the jurisdiction. If there are no other questions, I ask that you reverse the trial court's order alone, remand for additional instructions. Thank you for your time.
Thank you, counsel. I want to thank you both. It was well argued. It's been well briefed, and we appreciate that. We will now be in recess.